there is all types of letters of credit, and there are two basic types. There are commercial letters of credit, which are the traditional type that are intended to be paid. And then there's a newer type, been around now for 50 or 60 years, but called a standby letter of credit. So this is covering all of those. There are a lot of the concepts are the same, but we're talking about some of the differences. And so it's actually a lot of content to go through. Basically, what I want to focus on for people is understanding things that can go wrong. So if you have a letter of credit, what reasons might there be that you won't get paid even though you have a letter of credit? So we're going to go through the presentation and hopefully explain these as being the basic reasons. If the letter of credit has expired, if the documents that are presented in order to get paid are discrepant and cannot be corrected before the letter of credit expires, if the issuing bank is in a foreign country and there's a political event of some kind, like a change in regulations that prevents them from transferring money out of the country, or there are various other forms of that regulatory interference. If it is felt by a court of proper jurisdiction that there might be a fraud being committed, and then we'll get into some that are getting kind of subtle, but one of the big reasons, at least here in the United States, that credit managers at companies, in order to protect themselves from a risk of non-payment by somebody they're doing business with, and credit managers are typically the biggest part of the audience for this presentation, but anybody who has received a letter of credit as an assurance of payment is probably thinking that they're going to protect themselves from the other party, the applicant, the party who's received is called the beneficiary, and the applicant being the other party. Protect yourself from the applicant going bankrupt. There are particular issues if the applicant goes bankrupt that we'll go over. And there's also the possibility that the bank that issued the letter of credit could become the equivalent of bankrupt. Banks technically can't be bankrupt, but they would possibly become insolvent and get taken over by their regulators. And that would be, of course, even for a bank in the United States, but it also applies to banks overseas. So those are the general reasons. So let's go over why that happens. First thing to talk about is a definition. You know, what is a letter of credit? We'll get into some, subtle meanings here. What do these words mean? What's an assurance of payment? What's a guarantee? We talk a lot, and I'm probably a bit prone to this myself, to say that letters of credit are guaranteeing payment, but technically, we'll get into this during the day today. A guarantee is different. Does a letter of credit provide a security interest of some kind in the assets of the applicant? And are letters of credit conditional or unconditional? So these are a lot of misnomers about letters of credit. To tell you what a letter of credit actually is, this is a very short version. We're going to look at a little bit longer definition here in a second. But a letter of credit is not a guarantee. It's not somebody saying, I'll pay you if the other guy does not. It's not a security interest because you're not promising any property. Letters of credit are always conditional. There's no such thing as an unconditional letter of credit, even though people seem to like that description. They say, give me an unconditional letter of credit. A letter of credit is a bank's engagement. It's not the applicant's engagement being guaranteed. It's the bank's own engagement to pay the amount of the letter of credit or up to that amount upon presentation to the bank of documents that are specified in the letter of credit. The bank does that based on the idea that they're going to get reimbursed by their customer who asked them to issue the letter of credit. So that's where the bank is intermediating these risks. So the conditions are always presentation of documents. It's never a determination of whether something really happened. So like I say, this conditional versus unconditional actually doesn't make any sense. So here's a little bit more technical definition. This is paraphrased from the legal definition from the Uniform Commercial Code. So in the United States, Article 5 of the Uniform Commercial Code is the article that deals with letters of credit. This is not word for word from there, so I've made it more plain English. A letter of credit is an undertaking, usually on the part of a bank. There's nothing in the Uniform Commercial Code that says you have to be a bank in order to issue letters of credit. There is a provision in the Uniform Commercial Code that private